Lawless Laws and the Supreme Court. The core purpose of the criminal justice system is to establish truth and impose punishment. But when the process itself is used as punishment, the truth becomes irrelevant and the laws used to achieve it become lawless. These lawless laws seek, among other things, to make getting bail next to impossible, to allow for the use of extrajudicial confessions, and to place the burden of proof of establishing innocence on the accused. The Prevention of Money Laundering Act is one example of such laws. It was introduced in 2002 to tackle terror funding, but has been amended over the years to become a convenient tool for targeting political opponents and intimidating business persons. This becomes very clear when we look at the conviction rate. Only 23 people have been successfully convicted under PMLA, although 5,422 cases have been registered. The PMLA also shows that the process cannot by itself become the punishment without the active participation of the judiciary. This can be seen in the case of the Supreme Court's judgment in Vijay Madanlal Chaudhary versus the Union of India, 2022. A provision of the law was poorly drafted and was capable of two interpretations: that it required a person to project laundered money as legitimate or simply be in possession of such money. But in complete disregard of all established principles of interpretation, the court chose a much wider scope, in one stroke expanding the offence to otherwise harmless activities. What this means is that a person who has committed murder is far more likely to get a fair trial than a person who happens to find some money from the victims of murder in their pockets. The suspected murderer would be arrested and produced before a magistrate, be entitled to apply for bail on all grounds available under law, be protected from any extrajudicial confessions being used against them, and require the prosecution to prove their guilt. The person suspected of owning tainted funds, however, could be arrested at the whim of the officer of the Directorate, be held by the Directorate of Enforcement as long as it pleases, have next to no grounds in applying for bail, be compelled to confess their crimes and have their extorted confession used against them in court, and they would have to prove their innocence. This shows the court's complicity in undermining the basic principles of natural justice and rule of law. There are other such laws, like the Narcotics, Drugs and Psychotropic Substances Act of 1985, the Terrorist and Disruptive Activities Prevention Act of 1987, the Prevention of Terrorism Act of 2002, and the Unlawful Activities Prevention Act of 1967. However, striking these laws down is not enough if the court does not take people's rights seriously.